You guys let me know in the chats if I'm audible to everyone. Okay, cool. Have I started reading? Yes, I have. I've started wetting the book. Um, I've only read the introduction, and of course, I am skeptical as ever because I feel like the introduction last time also was very, very interesting, and this one, of course, is great too. But I'm gonna hold my horses before I pass judgment, I think. Are we live streaming today? Yes, we are. But I hope this is a more comfortable experience for you guys because I made sure that we are with fewer devices and it's like it's more comfortable for the members. Cool. Okay. Audible and amazing setup. Thanks, Lakshay. Your hairs are looking different. Thank you for noticing. Nobody ever notices. I had to point out to the book club I cut my hair. Nobody noticed. Guys, I'm not going to compliment myself, okay? But I will. I mean, if I have to, I will. But I'm happy. I'm kind of.
Apologize for not saying that you look nice. I didn't notice though. It's not like I didn't notice.
She's taking it so
I just
personally. Yes, that comment was directed at you, actually, Tanvi. So,
no, I didn't notice, but there's so many guys in the club. I was like,
mm.
will that be weird if you'll be like, oh, nice hair.
Yeah, it'll be such a like falling into such a stereotype. So I guess I
Yeah.
understand. You had to take one for all of womankind.
I
Uh,
definitely did notice.
yeah, thanks, bro. I'm happy I'm kind of famous with each live stream. Shout out to Kalyan, who is famous with each live stream. I did notice but didn't want to be a creep. I appreciate that as well. I do.
See, as a woman, I felt that way, so I can completely understand.
I appreciate it. I appreciate it, you guys. Okay, let's begin reading. We had left off at a very interesting juncture. Page number 234. Savarkar, in the last chapter, in this chapter itself, we read about how Savarkar was captured by the British authorities, and he had tried to flee when he was being transported from London to India, and they had made a stop at France at Marseille, and it was actually it's very exciting this portion of the book, and you cannot put it down, and basically a long story short, what had happened was he had tried to get out of the ship, like escape from the ship on which he was being transported by jumping out of the porthole. Now, all of us have like some amount of confusion as to like what is a porthole. I didn't Google it. I hope you guys did, or I don't know if somebody can, because I really, really hope it's the window in a ship. Because if it's anything else, because he's
It's the
escaped,
window only.
it's what?
It's the window.
Oh, thank God.
Circular window.
It's a circular window. Yeah, yeah. So I was confused about whether or not it was a window or it was the porthole in a lavatory. Like, yeah, everyone's clear about the other connotation. But so basically, that's how he escapes. He escapes out of the window from the, I guess, the bathroom window in the ship. He's being escorted by four officers. Two of them are high-ranking officers, uh, Englishmen, and there's two Indian constables with him. And actually, what happens is that the high-ranking British officers didn't even realize that he had escaped. In fact, they only realized that he had escaped after the Indian constables had captured Savarkar and brought him back to the ship. So that's how completely oblivious they were. The Indian constables chased Savarkar. So as Savarkar escaped from the ship's porthole, he swam to shore and tried to ask for a taxi. Once he got to Marseille, once he got onto land, and he realized that nobody really understood English, and that nobody would help him, because I suppose nobody could understand him. And also, I mean, I could imagine the state of him, right? Like drenching and completely helpless, probably looks like a homeless man, in a foreign country. It would be scary. It's like a horror movie. But in any case, he doesn't get help. In fact, what ends up happening is that a French police officer actually captures him and returns him back to the Indian constables who were chasing him. And as it turns out, this situation actually created an international disaster, because under the International Convention on Fugitives, which had been signed between France and England, any fugitive that had escaped to French territory would then fall within French jurisdiction, and the English authorities would have no jurisdiction over such a fugitive, even if he had run from English territory. So it created an international situation, because there was a question on whether or not the convention had been violated. Since a French police officer had captured Savarkar and returned him to the Indian constables, it was it sort of, the British argued that your own officers are returning this fugitive to us. So it's basically, yes, we have an agreement in place, but there is also an understanding that we extradite criminals who are we extradite English criminals who are on French territory. So basically, it amounted to something like that, a novation of the agreement. And also there was other factors that had to be taken into account, because the English authorities had informed the French police that they would be making a pit stop at Marseille, and they had this dangerous and really notorious criminal on their hands by the name of Savarkar. And so the English argued that you knew of the fact that we would be docking at your shores. You knew that we had a fugitive, in our custody, and you returned the fugitive to us, right? Like, so a French police officer, his actions would actually be attributable to the French government, because he's acting on behalf of the government. The French, on the other hand, argued that no, the French police officer acted in contravention of the International Convention, and that really it was out of inadvertence, and it was a mistake. It was an honest mistake on his part. And so the prisoner should not be, taken to Kalapani and should be returned to France immediately. And the entire battle was basically about ego, because the French ego was hurt that the English authorities chased a political criminal on their land when they had no jurisdiction to do it, and the French couldn't do anything about it. And so it wasn't, and this is made clear in the book as well, that it wasn't as if the French were super supportive of the Indian cause, but just that their egos had been hurt, that how could British constables or Indian constables come to French territory like this, or pursue a fugitive like this in French territory where France has exclusive jurisdiction, and France couldn't do anything about it and wasn't even made aware of the incident till it was too late. In any case, now Savarkar is being transported to India. Did we read that, has he reached India, or what has happened so far? Do you guys remember? I don't recall if he's reached India or not just yet. But basically, it was very interesting to read the how this event unfolded. What's also interesting is, as it turned out, we also read that Briand, the French Prime Minister, or Briand, I don't know how to pronounce it, the French Prime Minister at the time, was actually conniving with the British Prime Minister. And so, the Savarkar was returned back to the British authorities, and they had handled the entire international situation in favor of the British because of such connivance, even though the French press and French revolutionaries and, of course, the Indian revolutionaries who had taken asylum in France were very much against the British pursuing Savarkar in French territory and taking him back to Kalapani. They believed that the British should return Savarkar to the French authorities because they lost jurisdiction on Savarkar the moment he entered French territory. There was also a discussion on sorry. We were also discussing how Savarkar was in the situation in the first place because he had voluntarily chosen to go to London, knowing that he would be arrested the moment he arrived at London, and that's exactly what happened. And Madam Bikaji Kama and Shamji had warned him against this, and he did so anyway. But at the same time, once he realized that he had been captured and he was being transported to India, he tries to escape. So we were like talking about how there is this juxtaposition of like, did he regret his decision, or perhaps he realized that the English are not going to be as fair as they portray themselves to be, because there's a clear agenda. There's a clear agenda here to penalize him at all costs, because we'd also read about how the British had extradited him, had arrested him and labeled him as a fugitive on false charges that were still to meet trial, so they weren't entirely established, and Sampath writes very clearly on how they were even fabricated. So and this was also pointed out by his lawyers before the English courts, but the English courts did not listen to reason at the time, and they decided that it was best to have him sent to India, where many of his rights would be compromised, because Indian laws were a lot more draconian than the British laws at the time. So, and this is why everyone fought tooth and nail for Savarkar to not be returned to India and to be tried in Britain itself. But that did not happen. All right. Page number 234. Actually, let's read from page number 233. Let's read from page number 233 just so that we have some sense of continuity. Okay? Sorry, 1 second. Okay. He further nitpicked on the action of the Indian head constables. I'm reading on page number 233, middle of the page. So if you guys have the book, you want to open to that page, you're more than welcome. All right. He further nitpicked on the action of the Indian head constables in hot pursuit by stating that there is no rule in international law which prevents a foreigner in a foreign country from assisting a police officer in the performance of a lawful act of seizure. His submission was that the constables were merely assisting the French gendarme, the police officer. They might have gone a bit overboard, but that could not be construed as a violation of France's sovereignty. The case, therefore, Robson concluded, is not of a criminal who has been handed over in violation of the conditions of an extradition treaty, but of an alien who has been excluded from French soil, which he had no right to enter in the very first place. He did not think Sir Edward Grey would be justified in promising a surrender of the prisoner to France, nor could the executive interfere with the judiciary at this stage of the proceedings. So this is the Attorney General, Sir William S. Robson's opinion on the issue. The Attorney General naturally was representing the British government at the time, and he believed that no international law had been violated and that Savarkar should not be returned by the British authorities to French soil. Meanwhile, the government of Bombay was getting restless about the undue postponement of the case. The governor shot off a telegram to London on 5th August 1910, in which he seemed to contradict the narrative that the Foreign Office was constructing. It said, the gendarme to whom Savarkar ran failed to understand what he said, and Savarkar, according to his own statement, was seized by the constables in pursuit, who were immediately assisted by the gendarme. The statement of the other constable is that the pursuers were joined by the gendarme, and that the capture of Savarkar was effected on his stopping partly because hindered by dock employees and partly owing to exhaustion. So as you can see, what has happened is Savarkar was running, he was being pursued by these Indian constables. He was exhausted, and the Indian constables grabbed him and they were assisted by the French police officer, and then accordingly Savarkar was returned to the ship. The narrative that they are trying to construe is, no, this is not what happened. The Indian constables did not grab him first. It was actually the French authorities who had returned him to the British authorities, and that's how he was escorted back. This may seem like a tiny detail, but it matters because if the French authorities had caught him first and voluntarily returned him to British authorities, then that would, to a great extent, make a good case for the British that the French voluntarily returned him. On the other hand, if the Indian constables were the one who got to him, were the ones who got to him first, and he was forcefully dragged away and only assisted by the French police officer, then that would mean that the British were in active pursuit of a fugitive on French soil, which is a violation of France's sovereignty. So the narrative that they are trying to construe is the former, wherein the international convention was followed, and it was actually the French authorities who had voluntarily returned Savarkar back. All right, I'm going to continue reading. The governor was lightly admonished in a return, and one more thing: the governor's telegram to the Foreign Office is clearly in contravention to the narrative that they are trying to construct for the world. So this telegram sort of throws a little bit of light on the truth on what really happened, which is that the Indian constables were in active pursuit and they violated not only the treaty but also French sovereignty. Anyway, the governor was lightly admonished in a return telegram dated 15th August from the Secretary of State for ruining the well-crafted narrative, stating that it is unnecessary to point out that the question of what happened at Marseilles is to be left for discussion by the two governments concerned, and that as the publication of the version given in your telegram of the 5th would cause inconvenience, questions relating to these details should be kept out of Indian courts. Okay. Sorry. Subsequent telegrams exchanged between the two conveniently bolster this new narrative, and all the previous testimonies of police officials were happily disregarded, almost confirming Guy Aldred's accusation of French Prime Minister Briand's connivance with the British. The government of France managed to secure a deposition of Brigadier Pesque that he single-handedly captured Vinayak by his right hand, and that the head constables had little role to play in it. The Secretary of State informed the Governor of Bombay by 31st August that further postponement of the trial would not be necessary, as they would inform the French government that the proceedings could not be stopped, and if required, Vinayak could be restored to them after the Indian court had pronounced its judgment. Accordingly, on 10th September, Vinayak was committed for trial before the special tribunal upon charges framed by the magistrate under sections 121 and 121A of the IPC, and also on a charge of abetment of murder under section 109 and 302. Coincidentally, on the same day as the trial commenced in Bombay, miles away in Copenhagen, the Socialist Conference of Europe, that was holding its session in that city, demanded Vinayak's immediate return to France. With all the new evidences by 24 September 1910, Sir Edward Grey's narrative was embellished with more details of what transpired at Marseilles. He noted that once the Moria docked on the noon of 7th July, a commissaire special of the port, Monsieur Leblay, came on board, showed Parker the letter exchanges between Sir E. Henry and Monsieur Hennion, and also saw Vinayak in the cabin. He then took Parker ashore and introduced him to the officer in charge of the police on the quay. There were 4 or 5 gendarmes in uniform. Addressing his officers, the commissaire special said, "Let me introduce you to the English police officer who has an Indian prisoner on board. You must give him any assistance he may require and prevent any strange Indians from assembling on the quay or going on board." Whether these were true or a careful post facto reconstruction of events to suit the British narrative is anybody's guess. None of the police officers on board the Moria, both British and Indian, had ever brought up this vital detail in the departmental inquiries. And one wonders how Sir Edward Grey managed to unearth these facts now. In his own sworn testimony of 24th July, Inspector Parker, when asked what had happened on arrival at Marseilles, had said, "Between our arrival at Marseilles and lunch, I went ashore for 5 or 10 minutes to be introduced to the shore police officials. This was as casual as it was made to appear and not as intricate and embellished as Sir Grey's version. It is incredible that Parker, who gave the minutest detail of their travel in his testimony, would have omitted this important incident." Interestingly, after the British government's strategic decision, Parker zoomed in on the time they arrived at Marseilles, adding fanciful details to it. The governor of Bombay's telegram dated 20th August 1910 shows how in less than a month, Parker managed to remember so much more than what he had testified to in a departmental inquiry. He suddenly mentioned the details of the commissaire special of the port who came on board and spoke to him in French, which he could understand only a little. He then showed him the letter exchanges. He even said that among the gendarmes who were introduced to him, Brigadier Pesky too was most probably one of them, although he could not be absolutely sure. It was a wonderful manipulation of concocted facts. Sir Edward Grey also took care to note that after his escape, Vinayak was arrested and conducted back to the Moria by a French gendarme. This officer never relaxed hold of Savarkar from the moment he arrested him till he was delivered on board the Moria. The testimonies of Amar Singh and Muhammad Siddiq were thus craftily airbrushed. Speaking of their role, Sir Grey, however, mentions the action of the ship's steward and 2 Indian constables, who, on hearing of the escape of Savarkar, had landed and taken part in the pursuit, seems, as a result of the fullest investigation, to have wholly confined to assisting the French police officer to escort Savarkar back to the Moria, and it can hardly be contended that there was anything unlawful or irregular in this proceeding. It is a common occurrence in every country for independent individuals to assist police officers if they think they need it in the execution of their duties. In any circumstances, the action of these persons on this occasion in no way affected the final issue, and being, as it was, cooperation with the French official willingly accepted by him at the time, it cannot be regarded as derogatory to French authority either in fact or in intention. Interestingly, as per this account, the head constables had merely heard of the escape and not seen it themselves, as they had testified solemnly in their depositions. Sir Grey argued that Ambassador Cambon's demand to restore Vinayak to France on the grounds that he had acquired a right of residence and asylum on French soil was negated by their authorities at both Paris and Marseilles. Moreover, Vinayak was not a French citizen to lay claim to such a right which could be made by France only if it felt that its sovereign rights had been violated. But with this new reconstruction of events, that possibility too had been effectively negated. He cited the case of one Lamarande in 1866. A French criminal, Lamarande, who was a cashier at the Poitiers branch of Bank of France, had escaped to Canada, where his surrender and extradition was demanded by the government of France. Before the legal proceedings of extradition could be completed, the French consul applied to the British Governor General for a warrant by the latter for the immediate dispatch of the prisoner to France. The Governor General, in complete ignorance of the legal proceedings that were underway for extradition, issued the warrant and the man was shipped off. Before the mistake was discovered, he was given to French custody on board the French ship, and it was too late to prevent his departure. This case, according to Sir Grey, presented striking similarities to the Savarkar case. Concluding his argument, Grey mentioned that in case the French still did not agree, the British government was open to submitting the matter to arbitration in accordance with international law. The French government was totally taken aback by this argument and was found fumbling for a response. Ambassador Gambon called the British Foreign Office in panic and conveyed that the likelihood of Minister Picon being attacked violently in the French chamber was considerable. They desperately wanted to get the trial in India postponed. Cambon explained his difficulties that the French chamber saw no distinction between the jurisdictions of the British government and the Indian government. But the British government was not going to budge. Neither was it willing to give any assurances to their French counterparts. Clutching at straws, the diplomat at the French embassy in London, Émile Dachna, wanted to know if an oral assurance that Vinayak would not be executed in India could be given confidentially. An amused Morley suggested that Sir Grey instead give a formal assurance that whatever may be the result of the trial of Savarkar, no step invoking irreparable consequences will be taken pending the settlement of the international question. Accordingly, by an exchange of notes dated 4th and 5th October 1910, Britain and France agreed to submit to arbitration. On the one hand, the questions of fact and law raised by the Marseilles episode, and on the other hand, the demand of the government of the Republic of France with a view to the restitution to them of Savarkar. On 25th October, an agreement was concluded between the two governments about the constitution of such an arbitration tribunal and the questions to be placed before it. The following articles were drawn up for the tribunal. Question number 1. Should Vinayak Damodar Savarkar, in conformity with the rules of international law, be restored or not be restored by His Britannic Majesty's government to the government of the French Republic? Second, the arbitral tribunal shall be constituted of 5 arbitrators chosen from the members of the permanent court at The Hague. The 2 contracting parties shall settle the composition of the tribunal. Each of them may choose as arbitrator one of their nationals. On 6 December 1910, each of the high contracting parties shall forward to the Bureau of the Permanent Court 15 copies of its case, with duly certified copies of all documents, which it proposes to put in. The Bureau will undertake without delay to forward them to the arbitrations and to each party, that is to say, 2 copies for each arbitrator and 3 copies for each party. 2 copies will remain in the archives of the Bureau. On the 17th January 1911, the high contracting parties will deposit in the same manner their counter cases with documents in support of them. These counter cases may necessitate replies which must be presented within a period of 15 days after the delivery of the counter cases. The periods fixed by the present agreement for the delivery of the cases, counter cases, and replies may be extended by mutual agreement between the high contracting parties. Fourth, the tribunal shall meet at The Hague on the 14th of February 1911. Each party shall be represented by an agent who shall serve as an intermediary between it and the tribunal. The arbitrary tribunal may, if it thinks necessary, call upon one or the other of the agents to furnish it with oral or written explanations to which the agent of the other party shall have the right to reply. It shall also have the right to order the attendance of witnesses. The parties may employ French or English language. The members of the tribunal may, of their own choice, make use of the French or English language. The decisions of the tribunal shall be drawn up in 2 languages. The award of the tribunal shall be given as soon as possible and in any case within 30 days following the date of its meeting, at The Hague or that of the delivery of the written explanations which may have been furnished at its request. This period may, however, be prolonged at the request of the tribunal if the 2 high contracting parties agree. Very standard stuff in international law. Alright. The agreement was signed by Paul Cambon and Sir Edward Grey. It was decided that any other points in connection with the arbitration that might arise and which were not provided for by the agreement would be determined by the provisions of the International Convention for the Pacific Settlement of International Disputes, signed at The Hague on 18th October 1907. The Hague Tribunal, formerly known as the Permanent Court of Arbitration, owed its existence to a Europe-based agreement which later became international law codes. The composition of the tribunal for the Savarkar case was agreed upon as follows. Okay, I'm not going to read the whole thing, but essentially there's one Minister of State at Brussels and a member of the Belgian Chamber of Representatives. Earl of Desart, KCB, former Solicitor to His Majesty's Treasury, from France, legal advisor to the French Ministry. Okay, pretty standard. One minister from Britain, one from France, one from Belgium, like neutral parties basically. And it looks like a 5 or 6 judge bench. Yep. Alright, anyway. Sampath continues. They were all members of all of the people appointed in the tribunal. They were all members of the Permanent Court of Arbitration at The Hague. Ire A. Crow of the Foreign Office was to be the British agent. The best course of things would have been to allow this tribunal to settle the case between Britain and France and then continue the trial back in India. The tribunal was anyway mandated to settle the case by February-March 1911. The London press castigated the British government for the mess it had gotten itself into. As a sharply worded editorial in the Times noted, it is of course deeply to be regretted that the fate of such a prisoner should, in the event of his conviction in the Indian courts, be dependent upon the decision of another tribunal on points of international law, which, however important in themselves, are wholly irrelevant to his actual guilt. But for this, we have unfortunately only to thank the ineptitude of our own officials responsible for sending Savarkar in a ship that touched at any foreign port, whilst there were so many ships available that sailed directly from England to India. And secondly, that of the officials actually in charge of Savarkar during the voyage on board the Maria, through whose inconceivable negligence he was allowed so obvious a chance to escape. The homeward mail from India, China, and the East lamented. So, the name of the newspaper is Homeward Mail from India, China, and the East. And it writes, every thinking person reading the account of the escape and recapture of Savarkar at Marseilles must be filled with a sense of humiliation. The administration of this country has again been brought into withering contempt. Savarkar was in custody on charge of waging war against the king and abetment of murder. His guilt or innocence will be determined by the courts. It is perfectly immaterial to our point, which is that he was in custody on a very grave charge. 4 police officers were deputed to bring him to Bombay for trial. How did they discharge their trust? It was obvious, even to the meanest intellect, that if Savarkar meant to escape, his one chance was at Marseilles. Many leaders, activists, and legal experts also expressed their displeasure at the double standards of the British government for allowing the trial in India to continue even as the arbitration at The Hague was underway. For instance, the Committee of the International Arbitration and Peace Association, London, was quite annoyed with the continuance of the trial in India. They passed a resolution on 27th October 1910, which said as follows. This committee, while expressing satisfaction at the reference to the Hague Court of the question of the legality of the arrest of Savarkar on French soil, protests against the continuance of the trial until the decision of the Hague Court has been given. In view of these circumstances, the committee urges that the tribunal shall be called together with the least possible delay. Le Humanite, I don't know, looks like a French newspaper, I don't know how to pronounce it, noted with alarm of the news of the trial having commenced in India. What we wish to stigmatize is the gross indifference of these magistrates, who, without having the elementary courtesy to await the results of the negotiations actually in progress, proceed, despite everything, to try Savarkar, if we can call such a procedure a trial. But the British government could not care less for such dissent and was simply unwilling to put the Nasik conspiracy trial on hold. All these suggestions to defer the trial were disregarded. On the other hand, it was mandated to expedite the hearings and wrap up the case by the end of 1910 or by Jan 1911. Vinayak was too dangerous for the British government to be left locked up in a jail, that too in India, awaiting trial. Even as these hectic international parleys were underway, Vinayak's fate hung in the balance in what was to be a sham of a trial, its outcome a foregone conclusion. Bombay, September 1910. But before I continue reading, just want to see some of your comments. It's pronounced Zondam. What is? Windows a metaphor where we are live, so have to censor ourselves. You do not have to censor yourself at all. It's the Zoom meeting itself is not being streamed, so you can always. Oh, so it's pronounced as Zondam. Yikes! That is. Why would you spell it as Gendam if you wanted to pronounce it as Zondam? Doesn't make any sense. Alright, I'm going to continue reading though. I hope I don't have to battle this word again. Pasque is pronounced as Paschi. Come on, that's a joke. It's France, baby. Yes, they're all drunk on wine all the time. They don't know what they're writing. Okay, I'm going to continue reading though. Right, we read for 5 more minutes and then we pause to discuss, right? Yes. Okay. Bombay, September 1910. The special tribunal, without a jury and with no right of appeal to the accused, began its work in September 1910 in Bombay. So, like I said, the rights in India were substantially limited. This is a special tribunal formed specifically to try people like Savarkar, freedom fighters, patriots, people who basically would fall under sedition and waging war against the British government. Same provisions that, by the way, our Indian Penal Code still retains, although they have acquired a different relevance over a period of time. But anyway, and this special tribunal did not have a jury. It had a British judge, and also it had no right of appeal. So if the decision went against you, you could not appeal to a higher court of law. This was it. This was the final verdict. Right. Now, Sampath writes on. It consisted of Sir Basil Scott, the Chief Justice of Bombay High Court, Justice Narayan Ganesh, Savarkar, and Justice Heaton. The prosecution counsels were the Advocates General of Bombay, Jardine, Weldon, Wellinger, and Nicholson was the public prosecutor. Defending Vinayak and his co-accused were Joseph Baptista, Govind Rao Gadgil, Chitre, Setna, Thakur, and Rane Ginekar. Vinayak was moved from Nasik prison to Yeravada in Pune and then to Dongri jail in Bombay. There were 3 trials that Vinayak faced here. In the first one, known as the Nasik conspiracy case, there were as many as 38 other co-accused. There were nearly 278 depositions that the prosecution had lined up between Jan and April 1910. When the proceedings began on 15 September 1910, Vinayak was brought to court in a special van and with extra special security given his notoriety. It is said that the moment he entered the dock, he heard the sound of claps. When he looked at the vacant benches and galleries and wondered who was clapping, he realized that it was all the other co-accused in the dock below him. It was here that Vinayak also saw his younger brother, Narayan Rao, after a long time. The 2 siblings exchanged affectionate looks and non-verbally boosted each other's morale. The government had managed to secure 4 approvers in the case: Kashinath Ankushkar, Dattaraya Joshi, W.R. Kulkarni, and Chaturbhuj Amin. At the commencement of the proceedings, Vinayak's counsel, Baptista, raised At the commencement of the proceedings, Vinayak's counsel, Baptista, raised the fundamental issue of the validity of the proceedings and the ongoing international role related to his arrest. He said, Savarkar was prevented from holding any conversation while the P&O liner Moria, on which he was being taken out to Bombay, was in French waters. Savarkar, on arrival at Marseilles, requested to be landed, claiming that he had been wrongfully arrested. This request was, of course, refused. Not only this, 2 French police officers went on board the Moria but were not allowed to speak to Savarkar. He then determined to escape. Having gained the shore, he saw that 2 English detectives and 3 of the Moriah's officers were in pursuit. He ran about 300 yards, but his pursuers gained on him. He then turned to a French. How do you pronounce this word again? Can I just say gendarme? Can I say that? I'm gonna say gendarme. Hope I get away with it. The French will outrage. Okay, we'll take care of them later, after the session. He then turned to the French gendarme, yikes, for help, asking to be taken at once to the commissary of police. At this moment, the detectives arrived, and one of them took Savarkar by the neck, the other by the arm. In this brutal fashion, he was taken on board, put in chains, and kept in secrecy. So this is what Vinayak's lawyer says. The judges instantly overruled the objection. In its 28 September ruling, it said that since the prosecution had a single vast conspiracy to expose, it would be appropriate to try the pleaders in conjunction rather than separately. There were allegations of attempts to murder Gopal Krishna Gokhale and Justice Dinshaw Davar, who had arbitrated against Tilak in the 1908 sedition case. Hence, the court ruled that the ambit of the trial seemed more expansive than what was initially sought to be examined. On 1st October 1910, the court discussed the various provisions of the Extradition Act under which Vinayak was brought back to India. When repeatedly asked, Vinayak merely replied that he did not recognize the validity of the court that was trying him and hence would not wish to make any statements there. He clearly stated his judicial boycott. "I'm quite innocent of the charges laid against me. I took part in the proceedings of the trial in England, where in courts one can expect to get justice. There the authority does not rely upon brute force. The condition of Indian courts of law is quite the reverse. I'm not amenable to the jurisdiction of an Indian court of law. I therefore decline to give any statement or bring any evidence for my defense." The 5 charges that were pressed against Vinayak were waging war and abetting the waging of war against the king, IPC section 121, conspiring to wage war against the king, IPC section 121, collecting arms with intent to wage war against the king, IPC section 122, sedition, IPC section 122 also, and abetment of murder, which is IPC section 302 and 109. As the trial proceeded, some of these charges were dropped while others were expanded. For instance, the abetment to the murder charge was divided into 2 parts. The first charge was that Vinayak, while in London and elsewhere, engaged with certain specified persons and others not specified for the murder. The first charge was that Vinayak, while in London and elsewhere, engaged with certain specified persons and others not specified for the murder of officials of the Government of India. In pursuance of this conspiracy, he had sent out 20 Browning pistols from London to Bombay around February 1909. The consequence of this was that Anant Kanhare murdered Jackson in Nasik in December of the same year. The second charge was that Vinayak had conspired with the specified persons and others to overawe by means of criminal force and show of criminal force the Government of India, and yet again did this by sending Browning pistols. Vinayak's speech of 1906 and before in India were also put to trial for sedition. The various offences were clubbed under 3 cases titled the Nasik murder case, the Nasik conspiracy case, and abetment of murder and sedition. As part of the Nasik murder case, Kanhare, Karve and Deshpande had already been executed on 19th April 1910, and the others were yet to be tried. The Nasik conspiracy case had 38 accused, including Vinayak from Nasik, Bombay, Pen, Pune, Yola, Aurangabad, Hyderabad, and other places in the Deccan. All except one were Brahmins, mainly Chitpavans. 27 of them were found guilty and given various sentences. The trial went on for 69 days with more than 30 witnesses brought to testify. Amazing. Amazing to read these facts. All except one were Brahmins. That too Chitpavans. Three of the accused, Shankar Balwant Vaidya, Vinayak Sadashiv Barve, and Vinayak Kashinath Fulambrikar, were discharged earlier in the trial because they had turned approvers. According to J.A. Guider's deposition, it was the investigation into the Jackson murder that had led the police to unravel a widespread network and to the discovery of arms of various sorts, and also revealed the existence of secret societies for the overthrow of the British government in different parts of India. The plot began to unravel with the investigation of Ganu Vaidya on 23rd December 1909. Guider had merely found a piece of paper with Hemchandra Das's name on it during his raid on Baba Rao's house. As per British Colonial Criminal Code and procedure, this was sufficient evidence to implicate him. The links between the revolutionaries of Maharashtra and Bengal and their secret societies were a matter of great concern for the British government. And the fact that these associations began to emerge in the raids unnerved them. I don't want to start reading the testimonies because otherwise it's going to keep going. Right? This does not look like this segment is getting over anytime soon. Yeah. So we pause here for today. $2:43. No one tell on this, yeah. It's, well, the French are bound to see it because of course all of my 1090 subscribers will contact the French embassy to tell them what's going on. Chitpavan OP in the chat. Hi. Hi, nice to meet you. Swati sends a heart. Sorry, that might look creepy. It's about the session though. No. It's not at all creepy. Thank you so much. I really appreciate it. What did you guys think of what we read? It was a little legalese, I know. Little bit of legal jargon. And quite interesting to me actually, but I can understand if someone might be bored.
Today I felt as if I was reading J. Scientific in your Vikram Sampath.
That's true. That might have, yeah, I can understand that. But yeah, I suppose he did not have to go into great detail on what the trial was, but I think I trust his judgment because perhaps if he hadn't done that, then maybe we would not have understood the full extent of what has happened. And maybe for the people who do understand the subject, maybe he's trying to sort of show that how unfair the trial was, right? And the British government was really going after this guy with an agenda. And what I really sometimes I wonder, given how disliked Savarkar was by the British government, like how much of a role do you think the Britishers had in anointing the freedom fighters that would gain fame in the country? So somebody like Gopal Krishna Gokhale is pretty popular. Someone like Mahatma Gandhi becoming the father of the nation is pretty strange given that we had all these other heroes. So I'm just wondering, how much of a role do you think the British played in somebody like, let's say, Gandhi being anointed to the position of the father of the nation?
90%?
90% at least, easily. Right?
It's very nitpicked. Like they've picked up only politicians. You can't really call them
Freedom fighters. You
freedom
can't call them
fighters.
freedom
They're not
fighters.
freedom fighters.
Yeah.
I mean, Madam Ji Kama and all, they were on the footnotes. I remember they were just
Yeah.
they were just names. They were also freedom fighters. And considering the things they did,
Hmm.
they were the freedom fighters.
Yeah. they were the movers and shakers of the movement, but they seem to have been completely pushed to the sidelines. No, I agree, and it's a little bit disturbing, you know. So I don't know how many of you got this, but basically the dispute had been submitted to this international arbitration tribunal that had been constituted, and it had a number of members of obviously very high-ranking officers uh, from different countries. Obviously British, obviously from Britain, obviously from France, but also other European nations, and this tribunal was set up to specifically uh, look into the fact of whether or not the convention between the French and the English had been breached. What had exactly happened? Was it that the French officers had captured Savarkar and then returned him voluntarily to the British officials, or was it that British officials, or in this case the Indian officials, were in pursuit of Savarkar, uh, and the French inadvertently, not knowing international law, not being cognizant of international law, inadvertently assisted these Indian officials and escorted Savarkar back with them to the Moria. And this tribunal had been formed to, like, very specifically, first of all, to try this particular case, but also they understood that time was an issue. So they had very clearly agreed to the fact that we will wrap this up by March 1910. By 1910 or 1909? What year was this? But we will wrap this up very quickly, within 20 to 30 days of the written arguments being completed. Right, so there's a timeline established. But the British government is willing to overlook international law, and instead of waiting for the judgment to come from this particular tribunal, chooses to conduct its own trial and proceed ahead. So this was like this just shows how motivated they are and how quickly they want this over with. They want to, like, wrap everything up as soon as possible so that Savarkar is convicted, penalized, transported to Kalapani, and perhaps they could then, if he was convicted, then they could claim that this man has been convicted for murder and we can't just hand him over and this and that. So basically they wanted to seal the deal as soon as possible, so that they don't have to, so that should the international law verdict go against them, they have, like, a better defense, or perhaps another layer of protection, which is that Savarkar is a convicted felon and he should not be returned to French soil. Right? We had to get we had a cooperation treaty till 1966 with the British. So post independence also they called the shots. Yeah. What did they entail? I had no idea. Sorry, what do you mean, Tanvi? What did they entail as in?
I was asking Kalyan about the cooperation treaty.
Oh, okay. All right. We had to get English permission and tell British intelligence almost everything. That was part of the treaty. Really? I did not know that. That seems like an awful lot of... And you say it was signed in 1966. That's a very long time after independence. Why though? That doesn't make any sense.
1966. That treaty ended in 1966.
It ended in 1966. Okay. That's but still though, that's like what, 23 years? Indira Gandhi stopped that in 67 when she became the Prime Minister. God, Indira Gandhi is a real mixed bag, isn't she? It's she's a real mixed bag. Like, I can understand how she could be passed off as a strong leader and a strong woman, but she was a dictator at the end of the day. So, but also, I mean, this is an admirable move to really to stand up to the British. I mean, that, especially given the shoes in which India was in at the time, that's a big deal, and that takes like a spine. Cut to like...
Nobody do that before.
I don't know. I
Let's
don't
see how
know.
did it even continue.
Yeah, probably because that I was thinking about that line that Gandhi had mentioned that after Madan Lal Dhingra's execution, Gandhi wrote that article, right, in the Indian Sociologist or some other newspaper, I'm not sure. But he said that the reason that we should condemn the execution of Curzon Wiley, so the assassination of Curzon Wiley by Madan Lal Dhingra, is because if we allow for independence to be taken this way, then in place of the British, we will have murderers ruling. Because essentially, if the British are leaving India because of all of these political murders, then it stands to reason that the people who will come into power after the British leave are going to be these murderers. And
That's okay.
yeah,
Sorry.
no. What I mean is that logic applies almost everywhere then. And
Exactly. I've been.
if I'm rolling with that, then I would also argue that the Indian National Congress being formed by the British simply just took over and was doing the Englishman's bidding. And the same logic applies then that if you took power by petitioning and praying and pleading the British government, then you are basically going to hand over power to a bunch of weasels who do not have a spine and who cannot stand up to the British because they've
Which is
always,
what happened.
which is what happened. So I do think that there is some truth to that. I would rather have been ruled by those set of murderers who are willing to risk everything for the country, and instead of where we are today, because I have the confidence that such murders were never done out of uh, malicious intent for that British officer personally. I don't believe that Madan Lal Dhingra had anything personal against Curzon Wiley, but it's just that the death and the destruction that the actions of Wiley had caused is what led this man to give up everything and decide that Wiley had to be killed to save his country. So I don't think that it's personal, that there's any kind of like a vendetta against this particular man as such. It's not vengeance for anything that personally happened to Dhingra, but because he thought that it was his duty to protect his country from such an animal, is why he did what he did. And it's understandable. I mean, you wouldn't say that a soldier at our I mean an Indian soldier at the Indochina border is perhaps engaging in battle with a Chinese soldier out of a personal vendetta. No, the two do not have anything personal against one another, but they are fighting on behalf of country and for country, right? So I think that this has to be looked at the same way.
In fact, in fact, how the British retaliated was actually far more violent. Actually, they called a whole congregation of
Yes.
people, and they basically lectured the brother, right?
Yeah.
The cousin or brother, I'm not
Yeah.
sure.
Yeah.
They made him stand there.
Yeah. They use the brother's guilt, and it's also like it saddens me as well because uh, the British took advantage of and anyone would in their position took advantage of the family's servile attitude, right? The family was immediately they expressed Dhingra's family immediately isolated him, said, "Oh, we've got nothing to do with Dhingra. Do not associate us. We've disowned him. And how could he do such an act? How could he kill a British official?" And uh, I mean, what he must have gone through is, of course, like one ordeal, but another was to have his brother sit on stage as the I don't remember who the official was, who the British official was, who delivered a speech, talking about um, how vile Dhingra's act was. She was called Gungi Gudiya or muted doll by the opposition. Indira Gandhi stopped that in 67, yes. She was called Gungi Gudiya or muted doll by opposition. Really? JST covers the same point you just made in India, Bharat, Pakistan. Okay. Wow. Have you read the book? Have you read the whole book? Can you share insights as to how it is and whether we should take it up for our reading sessions. Here's the thing about India that is Bharat. Everyone wanted to read it.
Tough day. He says it's
Everyone wanted to read it. Nobody could. That was the hard bit. Okay. Everyone was like, I said, okay, do you guys want to read India that is Bharat? Yes, yes, yes. We're all in, blah, blah, blah. And then when it came to actually reading the whole thing, what, like 6 people towards the end were who really consistent with reading the whole thing, and that too, it was on and off, and it's understandable because it is a tough read. Kalyan says halfway through, tough read. Okay, so Bharat, sorry, what was the name of the book? India, the Bharat, Pakistan is also a tough read. Yeah, that makes sense. It's covering a lot of uh, difficult points. But you know what I really love? I love that guy's promotions. Like, I love how he promotes the book because, of course, I mean, like, he's, of course, trying to market his book better and all, but the sessions and the interviews he gives and the podcasts on which he appears are so good. They are so good. I love listening to him.
baiting us.
He's baiting us, and I like it. I mean, it's great, isn't it? For instance,
But I'm not going to get the book. I'll listen to all the interviews and I'll enjoy them.
that's fine.
okay.
It's okay. I have it with me. That's what I'm saying. I'm reading it. I'll vet it. If it's good, then that's great. We'll read it. If not, I'll try to read it and make content on it, so you don't have to read through the whole book necessarily. Reacted to his interview with S, with a thumbs up. His interview with Smita Prakash on ANI was amazing. Yeah, so that's the one I was watching. I really enjoyed the interview, and especially this one snippet where he's talking about the AIMIM and MIM and the founding
Yeah.
documents. I don't know if you guys have seen it. Great video. So good. So good. And this is the kind of stuff that you want to talk about. Like, this is information which is publicly available to anybody who is an expert either on the subject or just generally who's a journalist and who talk about these things. Unfortunately, it is strange that a lawyer is having to pick up the slack and sort of bring these things to light. His research of course is astounding, but I just wonder sometimes that if this is really so obviously and clearly available, why is it that we don't talk about it enough, and these things are not brought to light? Like, why is it that nobody connects the dots or makes that connection if all of these things are publicly available? Oh, surely. And I mean, it's not as if he's making like these outrageous statements either. He's talking very clearly and saying that the speeches that Owaisi makes in English are a very sanitized version of the things he presents to his Urdu audience or his, whatever, Muslim audience. And if you really were to dissect his 2 speeches, and if you basically listen to them even, you realize that they're completely poles apart. So somebody who's consuming his English content might think that, oh, this guy is very tolerant and he's very liberal and this and that, but that's not really the case. Secondly, the causes that Owaisi pursues are also extremely telling of his position. How he is willing to support the Rohingya cause, how he is willing to support the global Islamic cause, but is very, very hesitant, almost jittery in talking about the Hindu cause or talking about the Indian cause. Forget about making this, about a particular religious community. Let's just at least make it about the nation and at least look in him for a patriotic sentiment of some sorts. Even that is missing, right? So, and his position on Kashmir, for instance, is very clear. So it's available in public. We're not taught this. Also, 90% of India comes from science. Maybe you're right. The fact that we are more invested in STEM fields, perhaps, and it's good. Like, I find that even though I'm terrible at STEM or anything related to STEM, I find a lot of like I feel a lot of pride in the fact that we're coming from a nation which has such an aptitude and focus on STEM, but at the same time, it is so heavily lopsided in the favor of STEM and so against the humanities that we are suffering because of it. And we've had a lot of foreign influence when it comes to our humanities, and it shows, right? Um, I'm currently reading K.S. Lal and J.N. Sarkar, and they mention snippets of this. I would love to get my hands on those documents and just read on like how the MIM was founded, and just like look for answers, to these questions, because I think that these are the real questions worth answering that journalists unfortunately don't do enough research to look for. Shravya Amin says, I am in the second section of India, that is Bharat. All right, well, it's a good book. It's a good book. Read it slowly, pace yourself, and yeah, and I would say good luck. It's a great book for content. So anybody who is making the kind of content that I am, I found a lot of value in India, that is Bharat, and it's really changed the way I look at things now, and it's also opened a lot of doors for inquiry for me. So, for instance, the other day I came across a post someone sent me on how the Adivasi identity of India has been Brahmanized. They talk about how gods like Kali and like a bunch of other gods, Kali, Durga, I think, and a number of others, I'm forgetting the names, were all Shudra gods, or they were Adivasi gods, and then the Brahmins came and they sort of took over and completely put all of these gods in a Hinduized umbrella. I'm not sure what to make of that. I'm not sure where that information is even coming from. It reeks of the Aryan invasion theory, which has been rubbished by a lot of people. But it's disturbing that these facts are genuinely out there and these people believe that the information that they're putting out is factual. India, that is Bharat, poses a great starting point for anybody who wants to read up on the Adivasi identity and how it has been manufactured by colonial influence. Who is an Adivasi? How this definition has come across? What is the distinction between an Adivasi and someone who is a typical Hindu Brahmin? Would a Hindu Shudra not be an Adivasi? Are those two completely different categories? If so, how? What are they? Like, what are the definitions? These things are very well questioned, and there's good evidence provided for them as well. So every single time that I'm making content and I'm like going back to the book, I love to turn back to the bibliography of the book and see like what papers he has cited, and I think that those are very, very helpful. So especially if somebody wants to counter these narratives and or just for your own knowledge purposes, go back to the bibliography and see what papers he is citing, because he's done an incredible amount of research. So kudos to him. Alright guys, I think that brings us to the end of today's session. Anybody has anything to share before we end?
Are we doing a session tomorrow?
You tell me. Do you want to? Because I was swamped with shifting and everything, and I've only just gotten free. So I'm happy to do one tomorrow to make up for the time missed. But I also understand that a lot of you have busy lives. So you let me know on the group if you are up for it, and I'm happy to do it. How's Saturday sounding for you guys? So would you guys like to read 9 o'clock Saturday tomorrow? Or do you have a life? Just kidding.
I have a family commitment tomorrow. So.
Yeah, that's what I felt. Because the weekend is like that. Pallavi and Abhijay and Kalyan.
I'm okay for the evening, but night, pata nahi.
I get it. Tanvi, can you do like 6 o'clock or 5 o'clock or something like that?
No, this will be a lot. If I'm going pura, then I'll be out.
Got it. And you guys, Abhijay, Kalyan? Kalyan's up for it? Abhijay? Alright, fine, it's okay. I'll ask on the WhatsApp group. Let's see. If the majority cannot make it, then that's fine. We'll not do the session. We'll do it Sunday onwards. Sunday, so you guys are free, no?
Yeah, then I'm saying.
Okay, cool. All right, everyone. That is the end of the session. Thank you so much for joining in, and I'll see you whenever we decide next, I guess. Okay. All right. Bye, everyone. Good night. Good night. Bye.